Hello, good evening, and welcome to our webinar at Reasonable Adjustments in Housing Cases. I'm Nick Singer, an employment specialist here at 42BR Barristers.
And I'm Iris Ferber. I am a housing and employment specialist here at 42BR Barristers. Nick, you and I are going to have a chat this evening, aren't we, about reasonable adjustments claims and defences in the context of the landlord and tenant relationship. And now you're an employment specialist, I'm housing and employment specialist, and we're going to tease out some of the differences and similarities between those two areas of law. Those of you who are watching live, there is a live Q&A box. And any questions that you may have, please do put them into the Q&A box. I've got my trusty iPad here and the questions will come up in front of me and we will deal with them as we go along. For those of you who are watching this a bit later, if you have any questions, please do email them to events@42br.com. That's events@42br.com. And we will email you back if we can, if your questions aren't too difficult, with some answers. Okay, Nick, do you want to kick things off? Tell me, if I knew nothing about this at all, how would you describe what reasonable adjustments are?
Okay, so I'm going to take a 30,000 feet view, as if perhaps describing it to a friend at a pub, because of course, that's what I always do when I go to the pub. I regale my friends with tales of employment law. I don't have many friends, but yeah. The key thing is, of course, it's for disabled people only, and it's all about doing things differently to how you would do them normally. So there might be a normal way of doing things for people and a different way of doing things for a disabled person. And really what the duty is all about, it's about either doing something extra for those disabled people or not doing something you would normally do to help those disabled people.
Okay, so humour me here. If you're doing something extra, or if you are stopping yourself from doing something you would normally do, that will probably cost you money, or it could cost you money. Can you just get the disabled person to pay?
No, section 20, subsection 7, or only a few seconds in and we've a statute, but no, section 7, you can't ask the disabled person to pay.
Okay, all right. So this is going to come out as a bit of a theme of this. This is all pretty technical and you do have to refer to sections of the Equality Act to get it right. But having said that, let me ask you a general question. You've said that reasonable adjustments are about doing things differently from the normal. Is that a totally open-ended thing? Is it a duty to adjust particular ways of doing things, or is it anything you like?
No, there's not a general duty. There are 3 specific types of duty, which we'll explore to a different extent. But the first one is about PCPs. The second one is about physical features. And the third one is about auxiliary aids. They're the 3 general areas that we're going to look at.
Okay, well, there's already some jargon there, which I'm sure we're going to come to. But before we get there, I know this is not an issue for you or for me in employment cases, but let's remember that in landlord and tenant cases, only PCPs and auxiliary aids apply, not physical features. So right. Let's focus on those, and perhaps we'll come back to physical features a bit later and have a chat about those as well. So tell me about PCPs.
That's the first requirement, and it's one that comes up in the employment sphere the vast majority of time. So what is a PCP? It is a provision, criterion or practice. Absolutely crucial, provision, criteria and practice. Now, helpfully or unhelpfully, the Equality Act doesn't actually define it. But as employment lawyers, we look at the Equality and Human Rights Commission's Code of Practice on Employment, or for short, the EHRC Employment Code. So a bit of a mouthful. But what it says, and I'm going to read this out just to give you a bit of an indication of how wide it is. Yeah. PCP should be construed widely so as to include, for example, any formal or informal policies, rules, practices, arrangements, criteria, conditions, prerequisites, qualifications, or provisions.
It sounds a bit like someone swallowed a thesaurus.
Yes, indeed. It's a bit of a mouthful, but there's a lot. It's very, very wide, and
the same will apply when you're looking at PCPs in housing cases, right?
Yes, yeah, absolutely. Okay. And indeed, it can also include something you might do in the future and one-off decisions. There's a bit of case law about what a one-off decision can qualify, but we don't have to worry about that. I think the most important thing to take away is it is very, very wide, and tribunals trying to construe it widely as a result of that guidance.
And I think, just for pausing for a moment, county courts looking at discrimination cases in housing cases will also do the same thing. They will construe it widely, by analogy.
Right. Okay, so give some examples from the employment sphere of what a
Yes, please. I
PCP
think that'd
might
be
be.
useful.
So one of the things we will often see as employment practitioners is about attendance at work. And so you may have a PCP as simple as this. An employee has to attend work. And that might be relevant, as we'll see later, about in cases where an employee might be dismissed for poor attendance. It could be a target. So, for example, a typist having to do 60 words per minute, or someone at a till having to scan a certain number of items.
Okay.
It could be a pattern of work, a requirement to work certain hours, or a requirement to work at night. So it could be a number of different things.
So we're really talking about sort of pretty uncontroversial ways of working that are quite normal.
Yes.
Okay, well, and that's just the PCP. That's the provision, criterion, or practice.
Yes.
That is part of the first requirement in section 20. Okay, so let's illustrate that then and tell me whether this sounds right to you for a housing case. Let's illustrate that with an example from what might arise in a housing case. So you could have a situation, for example, where you are dealing with a formal policy that a landlord has for dealing with antisocial behaviour. They might literally have a policy that they publish that's on their website, headed antisocial behaviour policy, and a set of rules for how they're going to deal with antisocial behaviour. Would that be a PCP?
Yes.
Okay. What about, let's say that policy, that published policy, says nothing about what point in the process the landlord would choose to go and seek an injunction.
Okay.
At what point does the behaviour become that bad that they're going to go to an injunction? Let's say the policy is completely silent about that, but informally, that landlord always waits, say, 6 months from the first complaint, or always waits for 3 separate complaints to arise before they start to consider injunctions. Is that sort of informal way of doing things potentially a PCP as well?
Potentially, yes. It's obviously a question of evidence. Sometimes when it's not written down, we have disputes about these things. But yes, in principle, absolutely.
So I guess sometimes if it's not a written policy, I mean, if it's a written policy, the PCP is there written in the policy. But if it isn't written down, then presumably sometimes it's the evidence that you can get about what's been happening that tells you whether or not there's a PCP and what the terms of it are. So it might be based entirely on evidence of what happens in the day-to-day management of that landlord's business.
Agreed.
Okay, so right, so we've got as the first requirement PCPs. What about the third requirement? You said there was a third requirement.
Auxiliary aid,
Right.
and you'll go to section 20, subsection 11, and broadly speaking, the way it applies is the same as PCPs. But what is an auxiliary aid? Well, firstly, it can be a piece of technology which could assist a disabled person. So 2 common examples might be an induction loop. For those who don't know, it's a special type of sound system which can help deaf people with hearing impairments to hear. You might have voice recognition software for people unable to type, but the Act goes a little bit further. So it would include those kind of things, but also something called an auxiliary service. So that could mean a sign language interpreter or a support worker who supports a disabled employee.
Okay, so I think that translates quite neatly into housing cases then, because certainly things like hearing loops at housing offices for tenants or people who are visiting the housing office to talk about their tenancy, tenancy agreements being provided in Braille or large font format, and even tenancy support workers being assigned to assist a tenant with, say, mental health problems to manage their tenancy. Those are all things that we see all the time happening in housing cases. And if something like that isn't being provided and the tenant thinks it should be, they could say that that's a failure to provide an auxiliary aid. Okay, got it. So we've got those 2 types of case, PCPs, auxiliary aids. But, let's go back to our law studies. There's always a series of rules, questions to answer. If this, then this, if this, then this. What are the elements? What are the questions that a tenant has to prove if they want to prove that there's a failure to make reasonable adjustments for them?
Okay, so go look at PCPs. As I say, the vast majority of cases are about PCPs. So the first question, what we've been through already, does the person, the company, the employer, in my practice, do they have a particular PCP? Do they have a way of doing things? And that's what we've already discussed. Is it a policy? Is it a practice we can infer from the evidence? First question, do they have it? Second question, does that PCP put, or could it put, the disabled person at a substantial disadvantage when compared to non-disabled people? PCP, apply it, substantial disadvantage.
Okay, there's quite a lot in that, but the word that jumped out at me immediately is substantial. Does the PCP put, or could it put, a disabled person at a substantial disadvantage? So what does that mean?
Go to section 212 of the Equality Act, and what it means is more than minor or trivial. May come as a
that doesn't sound like substantial to me.
No, it's been defined by high courts, sort of put into the statute. But yes, more than minor or trivial. It does make it somewhat easier to prove than what you might expect from looking at the word substantial. But it can also be expressed as the phrase more than the normal differences between people.
And that's another way of saying the same thing, isn't it? So if let's again sort of imagine our antisocial behaviour policy example, everybody to some extent is disadvantaged by an antisocial behaviour policy, you could argue, because everybody could be the subject of an allegation of antisocial behaviour, and then they might have steps applied to them that might lead to an injunction or to the loss of their tenancy. Yeah. But there's a range of what would be the normal disadvantages suffered by people, and if this particular disabled person has a disadvantage that is beyond what's normal, that could be substantial.
Yeah, absolutely. And I'll give you some examples from the employment sphere, which I think helps put it into practice, that how it works. So I'll go through the ones that we discussed earlier. So we have the PCP of attending work. As an employee, you have to attend work. But imagine if a disabled employee has difficulty attending work due to their disability. It affects their ability to come, and therefore they're not at work as often. They will have a more than minor or trivial disadvantage compared to their non-disabled colleagues who won't struggle to get to work in that comparison. And that makes them more vulnerable potentially to dismissal or a warning, because of course a lot of employers have an attendance at work policy. So that's one.
Okay.
The PCP of targets that we talked about earlier, say a typist or someone who works on a till has arthritis, which is a disability, which means they can't type or put through the baked beans as quickly as their non-disabled colleagues. Again, it might be that they're subject to performance management, dismissal or warnings. And then the night work, or the fact that they have certain hours. Let's imagine someone with a mental health problem, they require sleep. So forcing them to do night work might put them at a disadvantage. It might hurt their health. And again, as is often the case in employment cases, the real issue, the meat of the issue is it going to be performance management? Maybe it affects what they earn or bonuses, or ultimately could be warnings or dismissal.
Okay, so I mean, applying that to housing in a way, actually, it maps across quite nicely. Let's stick again with our antisocial behaviour policy example. Let's say that the policy that the landlord has includes serving a notice seeking possession once there have been 3 allegations of antisocial behaviour. Let's keep it simple. Let's imagine that it is as straightforward as that. Or, you know, it's not a policy, it's an informal practice of doing it in that way. That could be a disadvantage to a person, let's say, with learning difficulties, who is perhaps more likely to have friction with their neighbours, perhaps more likely to make noise and not really be in a position to control that noise. Yeah. And then they'd have more complaints made about them than a person without learning difficulties, and they would trigger that 3 allegation level to be served with a notice seeking possession. And in those circumstances, that person is going to have that more than minor or trivial disadvantage. And a bit like your dismissal example, so a person who doesn't meet their targets might eventually get dismissed in a similar sort of way, which is why I think it maps across quite nicely. If a person with learning difficulties is subject to a notice seeking possession, that could eventually end in their eviction. So eviction being a bit like dismissal, in this case, the final potential outcome of the process.
Yeah. No, absolutely.
Sounds like that's sense.
Exactly it.
Okay, now you said when compared with people who are not disabled, and when you were describing the way that the substantial disadvantage is assessed. So does that mean that there is a formal comparator or comparison test in a reasonable adjustments case?
Yeah, so in discrimination law, often you need a comparator, someone you'd compare yourself to directly, and there's no requirement of a comparator. What you're comparing yourself to your colleagues. But the real reason you have this in this area of law is to help the tribunal, as it will be in employment law, to understand what the substantial disadvantage is. So, you know, you take the example of the typist. By comparing that person to other typists, you can understand what they're struggling with doing, what they're struggling with doing.
Other typists who don't have the
Yeah,
disability.
who don't have the disability, of course,
Right.
yes. And it's a lot of the time it is obvious what it is, but nevertheless, that's why, as part of the exercise, you've got to find the right group of people to compare them to.
And so it's basically, as I understand it from what you've said, the disabled person, the particular individual that is making, in an employment case, making the claim.
Yes.
In a housing case, the tenant who might be being sued, being pursued for possession, or might be making a freestanding Equality Act claim, how the disadvantage on them personally versus the disadvantage to people generally who are not disabled, to the sort of wider population. That's, I mean, it's a very easy comparison to make effectively, but there is some element of comparison there.
Yes, there's definitely comparison there, but I said in the employment sphere with their colleagues.
Yeah. Yes, understood. And so I suppose in a landlord and tenant case, it would be other tenants or other people who also live in properties let by that landlord. Okay, got it.
So we've got the first question. Where's the policy? Second question, substantial disadvantage when you apply the question. The third question is, does the disadvantage relate to a relevant matter, which is defined in the Equality Act as what a relevant matter is. But it does depend on whether you're doing an employment case, a services case, or a premises case. Now, I think as an employment lawyer, or when you do your employment law,
Yes.
this just never comes up because it's so widely drawn. It covers every area of employment, but as I understand it, it's different in premises case.
Yes, I'm going to talk about relevant matters in premises cases in a bit, but for each different part, premises, services and employment, Parliament has chosen to define relevant matter in a different way.
Right.
In services and employment cases, relevant matters are so widely drawn that you never really have to think about them. For whatever reason, in premises cases, relevant matters are quite narrowly drawn, and so you do have to engage with actually, is this disadvantage that is being suffered by this disabled person actually in relation to a relevant matter as defined. So we'll come on to what that means, but that is the third question in the test. Does the disadvantage relate to a relevant matter? Got it. Okay, so let's then look at the fourth question, and I'm going to pick this up because this is something that applies only in premises cases, only to cases about landlords and tenants. It doesn't apply in employment and it doesn't apply to services. And that is that the additional element that the disabled person has to ask their landlord to take particular steps, or to take steps generally to avoid a particular disadvantage. There has to be a request, not a request to discuss a PCP, not a request just to avoid a disadvantage, but specifically, this is the way that it's put in Schedule 4 to the Equality Act. There has to be a request to take steps to avoid the disadvantage. Now, obviously, that's not a technical test. The tenant doesn't have to use the words from the Equality Act in making that request, but they have to say, can you please do X, Y, and Z because this policy is causing me harm in some way. That's the sort of thing that has to happen. And we sometimes call that a reactive duty. So in other words, the landlord is only required to react to a request. Whereas in employment law, as we know, there is no requirement for an employee to ask for an adjustment. If there is a PCP, if the employer has knowledge that it is causing a substantial disadvantage, they have a duty to do something about it if it's reasonable to do so.
Yeah.
Okay.
Okay. So fifth question, hopefully we're keeping up, but fifth question, what steps need to be taken to avoid that disadvantage? And a sort of sub-question, is it reasonable for person A to take such steps? So we're working through it. It's always very important with these kind of claims to be very methodical in the way you break it down stage by stage. We've got a PCP that has put someone at a substantial disadvantage. So we're coming to the stage, certainly in employment, if you skip out some of the other questions, you come straight to this stage. How are we going to avoid this disadvantage? And then, of course, as I say, the point is about a balancing act between the need of the employee and the employer.
And actually, often that's where the battleground of the case
Indeed.
is, isn't it? Should any, okay, there's a policy. Okay, it causes this person a disadvantage, but so what? Is there actually a step that needs to be taken as a matter of law?
Exactly. And
Okay.
how does a court or tribunal determine this? Well, it's an objective test. The tribunal analyses it itself, whether something is reasonable. Now, before, under the precursor to the Equality Act, the Disability Discrimination Act, Section 18B1.
Very memorable section.
Easy section to remember. We use it so often, but there was a list of things that the tribunal had to take into account. Now, the Equality Act has done away with that, but nevertheless, these things are all relevant, and courts and tribunals are very likely to accept they have taken into account, not least because they actually make a lot of sense. They're actually very relevant and important things which you would expect to take into account and would make sense.
Okay, so this is the list of things that it makes sense for in a housing case, the county court judge hearing the trial to sort of work through in order to assess whether the thing that the tenant says should be happening, in order to remove the disadvantage of the policy, is actually a reasonable thing to do at all.
Absolutely.
Right. Okay. So tell me what is it they're going to need to look at?
So one of the big things, of course, is does it work? Is it effective? If it's not effective, then obviously it's not going to be reasonable.
It hasn't happened yet at this point, presumably. Otherwise, they wouldn't be in court about it. So how is that just a matter of evidence, whether it would work or wouldn't work if it was applied? It's hypothetical.
Yes, it is. It's a matter of evidence and arguments. Absolutely. There's another factor as to whether it's practicable, whether it actually works. The other thing I'll take into consideration is how big the employer is, financial resources. So a big company with 200,000-300,000 employees is going to be in a very different position to a high street dental practice.
Right. So translating that into landlord and tenant speak, a small landlord with very, very limited resources is going to be expected to do a lot less by way of adjustments than a local authority or a national housing association with a huge amount of potential resources specifically set aside to deal with what tenants need.
Absolutely.
Okay.
And to try and use some practical examples, trying to follow through the things that we've already looked at. So the examples I gave, the attendance policy I've described, as I say, there are usually trigger points in attendance policies. So, for example, an employee might be on a first warning if they miss 10 days a year, and they might be on a second warning 20, and it goes through. For a disabled person, you may say, all right, we'll give you longer. You can be off for longer than non-disabled people. Targets can be adjusted. So perhaps the typist doesn't have to do 60 words per minute. They have to do 40 words per minute. And
just pausing there, if you don't mind, Nick. So we were talking about the practicability and the effect it would have. So if I, as an employer, let's stick with the employment example, had good evidence that even with 20 days absence before the warning or before the next stage is triggered, that employee is going to have the 20-day absence. It's not going to make any difference to their moving through the policy, however many extra days I give them, unless I give them, such a high number of days as a trigger point that it becomes unworkable for me. That could be taken into account in deciding whether it's reasonable or not. The actual effect on the particular employer and employee of moving the trigger point on absence.
If it's pointless, absolutely.
Okay.
And of course, there may be some businesses where it doesn't make a great deal of difference. So if someone was off for a period of time, a very big business with a massive team, it may be quite easy to deal with it. But if there's only a couple of employees in the place and one of them's not there, it's going to have a bigger impact. So it goes back to that question of financial resources.
And so again, mapping that across to housing cases, you could have a situation, couldn't you? Let's imagine our hypothetical of an ASB policy where 3 allegations and you move on to the next stage, which might be applying for an injunction. If that individual who is causing the antisocial behaviour, their behaviour wouldn't improve, there would still be the same problems, whether it was 3 allegations or 10 allegations before you triggered the move to an injunction, or 20 allegations, it wouldn't matter, they'd still continue with their behaviour. Then it may well be that the particular adjustment of moving the trigger points to a higher number of allegations before going for an injunction simply wouldn't be reasonable, because it wouldn't make any difference.
I'd imagine you need fairly good evidence of that. I'd imagine tribunals and courts would be sceptical about they'd want good evidence to sort of dismiss it as a reasonable adjustment out of hand. But if you've got the evidence, and I suppose in a case like that, you'd have medical evidence, perhaps.
I think it probably would be, and you might go back. It might be a case of sort of allegations and counter allegations about what would be the right thing to do, what would be reasonable and what wouldn't, and maybe moving that trigger point of number of allegations. A landlord might say, well, that's not the right way of doing it. What would be the useful thing to do would be something else, provide further support, provide mediation between the neighbours. But let's say they could say, we've tried all of those things and they haven't worked. So those were the reasonable steps. They've already been tried. All that's left is this moving of trigger points, which the tenant is proposing. And for reasons which we have evidenced, that won't work.
Absolutely. It's so factual. I mean, there's an infinite variety of targets. You can change the target, but is that going to affect the business too much? And it goes a small company with only a couple of typists could be different from a company with 100 typists in a pool. Night shifts, how many people work the night shift? It just goes on. You just have to really dig down into the detail, and it turns on each business or each landlord, and you have to really dig down into the granular detail for this thing. And
actually, it also is the granular detail of that particular disability, isn't it? Because unlike sex discrimination, race discrimination, and other forms of discrimination, each person's disability is different. With two people who suffer from depression almost certainly will not have the same symptoms of depression. Each one will have their own symptoms and their own problems. So there are many variables. There's all the variables on the landlord side of the situation, the employer's side of the situation, and then there's all the variables on the individual disabled person side of the situation. What might be suitable as an adjustment for one person wouldn't work for the next person.
And that's why you've got to look very carefully at the substantial disadvantage, which is why you go through the questions very carefully, get all the information you need, and then
move through it in a logical way.
Yep.
Okay, so now that we've been through the definition of the duty to make adjustments, and we've done that by reference to PCPs, because really in almost every case, I can't think of the last time I ran a case about auxiliary aids or physical features in the employment tribunal, for example. It's always PCPs. And in the cases that are starting now to come up in the housing courts, in the county court and high court, it's also always all about PCPs. So we've focused on that and we've worked through all the elements of the test. Let's now have a look at the way Part 4 of the Equality Act works. That's the part headed premises. Now, first of all, how do the definitions that we've been discussing, so that's PCP, auxiliary aids, and how what the requirements are relating to PCPs, what the requirements are relating to auxiliary aids, how do those rules fit into Part 4? Part 4 starts at Section 32 of the Equality Act, way after Section 20. So how does it work? Well, it works like this. And again, this is something we never have to think about in employment cases because it's so wide that it's never an issue. But sometimes in housing cases, it's important to know how these things fit together.
Yep.
So Section 20 contains the requirements, what the duties are. Then this is important. Section 21 then says that a failure to comply with one of the requirements, so either the first requirement, the PCP requirement in a housing case, or the third requirement, the auxiliary aid requirement in a housing case, a failure to comply with one of those requirements is called failure to comply with a duty to make reasonable adjustments. That's what it means when you say a failure to comply with the duty to make reasonable adjustments. It's by reference to the requirements in Section 20. And then Section 21 goes on to say that if a person, so in a housing case, that would be the landlord, if a person fails to comply with the duty to make reasonable adjustments in relation to a particular disabled person, then that landlord is discriminating against the disabled person. So what Section 21 is doing is it's bringing into the word discrimination something that feels rather different, which is to say a failure to make reasonable adjustments. So we know, having been through that Sections 20 and 21 tell us that the word discrimination in the Equality Act includes a landlord failing to make reasonable adjustments for a tenant.
Okay.
Then let's go on to the rest of well, we haven't started yet. Let's go on to Part 4. As we said, it starts at Section 32. Section 32 contains various exclusions that we're going to come on to in a while. But then Sections 33 34 and 35 prohibit specific, prohibit discrimination in specific situations. 3 specific situations. And when we say they prohibit discrimination, we're not just talking about reasonable adjustments. The word that is used in sections 33 to 35 is simply discrimination, much wider than just reasonable adjustments. So it could include direct discrimination, indirect discrimination,
Right.
Discrimination arising from disability, harassment, victimization, and failure to make reasonable adjustments. Any of those types of claim could be discrimination. And sections 33 to 35 prohibit all of that behaviour only in particular situations. And I can't stress this enough. If you've got a tenant who's coming to see you, I'm talking at the screen now because you're not a housing lawyer, so I'm talking to the people who are watching us.
It sounds urgent.
It's urgent because people
it's actually
get it,
in bold.
It's bold in the notes. People get it wrong all the time. If a tenant comes to see you and their situation does not fit within the situations described in section 33, 34 or 35 of the Equality Act, they're not going to have a case. They're not going to have a reasonable adjustments claim or indeed any discrimination claim against the landlord. So what are these? What are these 3 situations? I'm going to finish what I'm saying and then I'm going to come to a question that's just come in. We'll go back a little bit and just answer the question, hot off the press. So section 33 of the Equality Act and section 34, in fact, I'll go through both of them together really. They both relate to things that are very rarely an issue. So we don't need to worry about them too much, but let's, for completeness, talk about them. Section 33 is discrimination being prohibited in relation to the terms on which somebody is willing to let a property or is refusing to let a property. So in employment, we sometimes talk about job applications.
Yeah.
In the premises part of the Equality Act, it's about whether the person is going to be allowed to enter into the tenancy at all in the first place. That's section 33. Section 34 really never comes up. It's when there's a third party that has to give permission for someone else to be granted a tenancy. And if that person refuses to give permission, that can amount to discrimination. It's never going to arise in the real world in any of the cases that we see. And then finally, the important one, section 35, and section 35 will be what everybody knows as the section that we plead when we prepare a pleading of housing discrimination, is discrimination being prohibited in relation to the management of premises which are already occupied by a disabled person. So that's like
being at work.
Being at work. Being at work, living in a particular property with a landlord. And what does management mean? Because that sounds like a very wide word. Well, that's defined. Management includes, it's not limited to this, but it includes how the person is allowed to use the facilities connected to the premises. So that might include, if they're living in a block of flats, it might be whether they're allowed to use the garden, for example, the facilities connected with the tenancy, whether they are evicted from that premises, dismissal, and any other detriment. Now, Nick, from employment law, what does detriment mean?
Well, widely drawn again, bit of a theme, but the exact wording of the case law says it exists, the detriment exists if a reasonable worker, there's an objective test, but if a reasonable worker would or might take the view that the action of the employer was in all the circumstances to his detriment. So very wide, doesn't have to be financial, it could be about stress or the way they feel. It can't be an unjustified sense of grievance. So it has to be justified, but as I say, it's very, very widely drawn. So it's so translating that into housing terms, if the person who lives in the house or flat reasonably thinks that the landlord's action is bad for them, then as long as that's not an unjustified feeling, that's a detriment. Yes. Okay, that really is very wide. It is very wide. Right, let's have a look at this question. So somebody has asked, apologies to who has asked this. I don't know who it is who's asked it. It's a good question. How does the court determine a landlord, a company or landlord's financial capabilities to finance reasonable adjustments? What would you say in if that was asked of you in an employment context? How is the tribunal going to assess financial
ability of a company to comply with reasonable adjustments.
Yeah, I mean, in my experience, I mean, the tribunal is not going to go too far into it. It's not going to expect absolutely reams of books. I think generally, as I've seen it, there'll be kind of an assumption, perhaps that's made about sizes of companies in terms of a bigger company is more likely to have more resources. And if it does turn particularly on that particular case, then perhaps the employer would call evidence about it's going through financial troubles or it's going through a redundancy process.
Or indeed that the particular adjustment is really expensive.
Indeed.
Because that's something that could happen. I mean, I in answer to that question, from my point of view, I would say quite a lot of the time adjustments don't cost very much at all.
Yep.
And then it almost doesn't really matter what the resources are. If we're talking about something that is inconvenient, perhaps, or the landlord doesn't want to do it, but it's not actually something that is a drain on resources, then the court isn't going to be terribly interested in how much it costs. But it's when you've got something that actually really does cost some serious money, that if you're representing a landlord, you want to say enough about it to persuade the judge that it's a real and genuine concern. I think you're right. I think that might be, if it's to do with the landlord lacking resources and there's a particular problem that landlord has at the moment about their finances, you want to explain that by way of company books or accountant's evidence or something like that. If it's more to do with, it's not that we don't have the money, it's just that this is really expensive, then you would want a witness who would say, this is why it would cost so much money to do this. Let me explain to the court how our business works and why this would actually cost so much money.
You're right. Sometimes it's the bigger picture. Going back to the attendance case, if a business has particular problems with attendance, so actually can work in kind of almost in the reverse with a big business.
Yeah.
Sometimes you see if there's a widespread cultural problem about attendance, even though they're quite a big business and the tribunal assumes where you've got money, but if it's almost an existential threat to the business because there's so much non-attendance, or it could be a safety issue. Sometimes you look at the bigger picture as well, which I'm sure again with landlords, either it might be a specific place or it might be a borough-wide problem.
And in landlord cases, you often have something that doesn't arise so much in employment cases, which is you have another neighbour, quite possibly vulnerable tenant who is very negatively affected by the way that the disabled tenant behaves.
Yeah.
So you've then got that to weigh up also, again, separate from cost. For example, again, to answer the specific question to do with landlords, if you're having to move successive people out from next door to this individual, and you're having to find all of them somewhere else to live and keep moving people in, and every person can't get on with that tenant and has to be moved, that's got a cost to it.
Yeah.
And you might be wise to attempt to prove that in some way.
And I suppose it again demonstrates, as per our discussion, these things are very, very fact sensitive, and it's crucial to be going to your client, whether it's the employer or the landlord, and giving them the list and all the ammunition you can to say why this is unreasonable.
Yeah, I mean, at the risk of repeating ourselves, the only way to avoid making mistakes is to have that list handy of all the different questions and make sure you're always answering all of them in every case. So let's just briefly talk about who has a duty and who is owed the duty. Now, if we were talking about an employment case, we'd be talking about the claimant and the respondent. The claimant would be the employee always. The respondent would always be the employer. That's not a particularly useful way of thinking about it in housing cases, because quite a lot of the time these issues arise in possession claims where the landlord is the claimant and the tenant is the defendant, and yet it's the tenant that is raising failure to make reasonable adjustments as a defence to the possession claim. So let's not think about it in terms of parties to litigation. Let's think about this in terms of what the Equality Act says about the person who has the duty and the person who is owed the duty. Section 36 of the Equality Act gives us the answer to that, and Schedule 4, paragraph 2. So Section 36 tells us who has the duty. It is any controller of premises that are either to let or have been let to the person. And controller means landlord or manager. So landlord typically, but actually a managing agent could also be subject to the duty to make reasonable adjustments as well. And it's not just premises that you're going to let to somebody. It's of course, once you have already let the premises to somebody, the duty continues. So those are the two types of organisations, landlords and managers of premises, that are subject to the duty to make reasonable adjustments. And then in Schedule 4, paragraph 2, the duty is owed not only to the disabled tenant, we've talked about disabled tenants quite a bit so far, but also a disabled occupier.
Yeah.
And that means, let's say you, Nick, are the tenant, but you have a wife and 3 kids and 2 of your children have disabilities. Those children may have claims potentially. If your wife has disabilities, she may have claims. The only question is, are they occupying? Do they live there? Not visitors, but occupiers. And as long as they are occupiers, then they could be people to whom the duty to make reasonable adjustments is owed. Okay, and then we touched a bit on relevant matters, and we said in an employment context, relevant matters is so wide that we never have to think about it. Whatever happens in an employment case, it's always going to be a relevant matter, as Section 20 refers to. In premises, it's a little bit different. The substantial disadvantage has to be in relation to a relevant matter, and the relevant matter is either the person's enjoyment of the premises,
right,
or the person's use of a benefit or facility that they are entitled to use because of the fact that they've got that letting. So it's not, for example, their right to a home generally. It is their enjoyment specifically of these premises and the facilities and benefits that they have as a result of living in these premises. That's important, and it can sometimes mean the difference between winning and losing a reasonable adjustments case for a tenant or for an occupier. Now, remember we said briefly earlier on that Section 32 has some limitations in it. So a lot of those don't apply particularly or are not really relevant to reasonable adjustment cases, and I won't go through them. A couple of them are so marginal and so rare that they just never come up. But one that's really quite important is Section 32, 3B, very memorable, which says that the duty to make reasonable adjustments under this part, under Part 4 premises, does not apply to accommodation that's provided under a public function. And obviously, to those watching here, that will immediately make them think of homelessness provision, because the provision of housing under the homelessness provisions of the 1996 Housing Act is something that only local authorities can do, and they do it as a public function, not as a landlord letting property. And those decisions made in homelessness cases, they are subject to a different part of the Equality Act, the public functions part, not the premises part.
okay.
Okay, let's say something about just a little bit of something, because we've got a little bit of time left. Let's say something about the second requirement in Section 20, physical features. Now, remember, we said doesn't apply.
It doesn't apply. PCPs, auxiliary aids do. This is the second one about physical features. But I think it's worth knowing what you don't need to know. So at least you could sort of make sure you're not getting in the wrong area. And then, as we'll discuss later, there are some potential overlaps. So I think it's good to just start with this.
Yes.
And really what this is all about is about physical features of a building. So we go to Section 20, subsection 10. It can be things like features arising from the design or the construction of a building, about approaching the building, having access to it, exiting it, fixtures, fittings, furniture, maybe widening a doorway or a wheelchair ramp. It's that sort of
or putting a handrail on a wall.
Handrails, these kind of things. And what Section 20, subsection 9 says, there are a number of things you could do to avoid the substantial disadvantage. You could remove the physical feature, alter it, provide a reasonable means to avoid it. But the examples we've just given. Okay,
so those are the things that would apply if the second requirement was a part of the duty on landlords. But it doesn't apply. I understand that. Okay, got that. So if I wanted to run a case about making changes to physical features and run that case against a landlord, I couldn't get a claim like that off the ground. It's just not an option for a disabled occupier. It just doesn't apply to landlords and management of premises. Okay, let me ask you a sort of a hypothetical, Nick, which I suspect you'll know the answer to because it'll be pretty obvious. But could I, do you think, just use the PCP provisions, what we call the first requirement in Section 20, to get around that prohibition on making alterations to physical features by saying instead, well, this landlord has a policy of not allowing alterations to physical features. So I think a reasonable step to avoid the disadvantage caused to my disabled client is to make a change to the policy and thereby make an alteration to the premises. What do you think? Do you think that could work?
You're trying to be a sneaky lawyer or a clever lawyer? You're trying to be clever.
Well,
I'm going to say it's a yes or no answer. I'll say no. I'm going to say
Correct.
no.
Correct. In fact, it's very easy because Schedule 4, paragraph 8 says reasonable steps to avoid a disadvantage, including a PCP disadvantage, so a policy related disadvantage, can never, the word never is used, can never include removing or altering a physical feature. So in other words, however you dress the case up, even if you're calling it a PCP or say an auxiliary aid rather than calling it a physical feature, it can never be reasonable for the step you have to take to remove the disadvantage to be the alteration or removal of a physical feature.
So Parliament thought of everything.
Parliament thought of everything. Well, they also, intriguingly, what they then did was apply some exceptions to that. So, you know, we love, again, from our law days, we have rules and then we have exceptions to the rules. Now we have exceptions to the exceptions to the exceptions, which is, you know, the fun part. So here are some exceptions to the exceptions. As a step to avoid or reduce a disadvantage caused by a PCP, say that again. So as a step to avoid a disadvantage caused by a policy, by a way of doing things, it is allowed by Schedule 4, paragraph 2, brackets 9, it is allowed to argue for certain specific minor physical alterations.
Okay.
So generally speaking, you're not allowed to argue for removal or alteration of physical features, except if you're arguing for, ready? Here's the list. It's a closed list. It's only these things that are allowed. Changes to furniture, right? Changes to equipment or materials. Provision or replacement of a sign or a notice. Replacing taps. Replacing door handles. Changing or providing a doorbell or a door entry system, or changing the colour of a surface, like a wall or a door or any other surface. So that's the list.
They came up with the list. I suppose
It must have been an interesting parliamenary session.
Yeah, it must have been a debate. I mean, they're relatively small, aren't they?
They are. I mean, I'm always amazed that rail, handrails aren't included. It's on for stairs, but they're not. So to repeat, these steps that I've just listed can potentially be reasonable steps to alleviate a policy disadvantage, but they can never give rise to a claim under requirement 2. There is still, despite what I've just described, no duty to make changes to physical features as a separate duty. Makes sense?
That makes perfect sense.
We've got a question, so let me see. Someone has asked us to provide that list that we just mentioned. Well, the list, if that's from a couple of minutes ago, so I reckon that must be the list that I've just been reading out. The answer to that person who asked the sensible question there is have a look at Schedule 4, paragraph 2, subparagraph 9 of the Equality Act. It sets that exact list out. It is there in Schedule 4. And in fact, Schedule 4 is quite readable. You know, it's not too complicated and it's not that many sections or that many paragraphs, and it sets out all the granular rules relating to how you apply reasonable adjustments in landlord and tenant cases. But Schedule 4, paragraph 2, subsection 9.
That's your homework. There won't be a test. There might be a test. Who knows?
Possibly. Okay.
I think something else has come up.
Someone has put a hand up, and hopefully in a moment, Sophie will.
Said something it was not that list, the list you mentioned before.
Okay. Well, hopefully, I think Sophie will in a moment send us, if the lady who's asked that question, if you could put that in, because I thought I saw a lady's name coming up, so apologies if I misread that. If you could put that in, whatever you want from us, into another question, then Sophie, who is doing a brilliant job forwarding the questions to us, will forward that to me, and then we will have a look at it. In the meantime, let's carry on, and we'll come back to that point.
So having talked to some other housing lawyers in chambers, there's a common issue that comes up. Can it be a reasonable adjustment to move someone to a different property? or a tenant to a different property, or the
yes.
the occupier. I don't know if that distinction matters in that.
Well, I mean, I suppose on the facts it might matter. Either way, it's complicated, is the
Yes.
answer. Whichever one it is, it's a complicated question. Let's have a look. That question has come in now
Right,
from the
okay.
person who asked it. Let's park that for a second. Let's
I'll
have a look.
to wait, bit of a cliffhanger.
Okay, it's the checklist, the general checklist of everything that needs to be considered.
Oh,
So,
fine.
Well, we're going to come back to that at the end, aren't we? So
Well,
if you
I think is that reference? I think that might be reference to section 18B1
perhaps what we'll do
of
is
the Disability
what I
Discrimination
suggest we
Act.
do, Nick, is at the end, once we've worked through our topics and discussions, at the end, let's talk through the checklist again, and perhaps you go back to section 18B as well and just give that reference again.
Fine.
And give that information again.
Let's do that.
Okay, right. So let's talk about what to do if the situation that your tenant is in is that they want to be moved to another property. Well, let's first of all ask the obvious question. Sometimes it's good to ask the obvious question. Does the landlord actually have other property that they could move the tenant to? Not every landlord does. Some landlords are small landlords that just don't have the facility to do that. If not, that's the end of it. But if you're talking about a local authority, which does have housing stock, or you're talking about a large national housing association, a registered provider of social housing, then they will have the facility potentially to move that person. But do they have a duty to move the person as a reasonable adjustment if all of the elements of the test can be established? Well, let's start. Do you remember we talked earlier on and you mentioned about sort of starting really with the question of disadvantage? That's sort of the nub of the first two or three questions that we're asking. Is there a policy? Well, that's usually easy. But then the next question is it causing a disadvantage? Well, I would say the first thing you want to think about when you've got a case, either you're making it or defending it, about potentially moving a tenant or any occupier. The first question is, why does the tenant or occupier say they are currently disadvantaged in where they're living right now? What is the nature of the disadvantage? And I think you can work backwards from that and work out whether you've got a case. So for example, it's usually good to give simple examples to illustrate the point before we look at complicated examples. So if the reason that this particular premises, this particular flat, let's say, is causing a disadvantage to me, is because of the way it's laid out. Is because I'm now in a wheelchair. I wasn't when I got the flat, but I now am in a wheelchair and I cannot get into the flat anymore. That's really, really, really serious disadvantage. But that is to do with the physical features of the flat. That's never going to be a reasonable adjustments claim. Now, people at the other end of this screen will be saying, but it's an unsuitable property. Okay, but that means you might be able to make an application as homeless on the basis that your current accommodation is no longer suitable. And therefore, although you are living somewhere, effectively you're homeless. That's a completely different thing from making a claim for a failure to make reasonable adjustments. And that's what we're currently talking about. So if actually what's wrong is that the premises are physically disadvantageous to the tenant, that's probably the end of your attempt to argue reasonable adjustments. What about if it's to do with the location of the premises? You're living somewhere where you don't have access to services or your support network is far away. Again, that could be a question of homelessness. It might be unsuitable for you as a matter of public law, but where is the PCP there? Where is the auxiliary aid? It's certainly not going to be an auxiliary aid to put you in a different part of London. It's difficult to see how that's a matter of policy if you're living somewhere that isn't where you want to be living. And there is an additional problem if we sort of work through that checklist, that the relevant matter that the disadvantage has to relate to is your enjoyment of the particular premises. And it often gets argued, and I'm afraid often successfully if you're for a tenant, that moving somebody to a completely different premises is not a way of resolving their lack of enjoyment of these premises. The duty relates to enjoyment of these premises, not enjoyment of one's home more generally. And so how can it be an adjustment to anything, whether it's an auxiliary aid or a PCP, to completely change the premises that the case is about. It would, I thought, by analogy, be a bit like saying to an employee who's disadvantaged by a particular way of working that an employer has, to say, well, why don't you go and work for somebody else? Well, that's just a dismissal. That's not dealing with the problem on the basis of the options that are available to that employer within that relationship.
Well, it sounds like it might be a bit of a crowbarring, as we say.
It is a bit of a shoehorning, crowbarring of arguments into possibly a claim that doesn't necessarily quite work. And one thing that does sometimes get argued, I've not yet seen a case fully argued to see if it works, is to suggest that the PCP is a particular transfer policy. So one of the benefits of this tenancy is that I am entitled to the benefit of a particularly generous, or not that generous, but relatively generous transfer policy, which allows me to seek a transfer to another property in certain circumstances. Because of my disability, for whatever reason, you'd have to have the right facts, I'm disadvantaged in using that transfer policy compared to people who aren't disadvantaged. I'll give you an example, actually. Some transfer policies say that if you've committed acts of antisocial behaviour, the landlord won't transfer you. So you could say, well, that disadvantages me because as a person with learning difficulties, I'm more likely to commit acts of antisocial behaviour, and then I can't have access to the rights to transfer that other people would have under this policy. And then you argue, well, then you could argue, this is a benefit I have as part of my tenancy, and an adjustment that would be reasonable would be not to apply those particular parts of the policy that relate to antisocial behaviour, and to agree to move me under that transfer policy, even though I don't meet some of the criteria relating to good behaviour. So there we go. There's a possible argument there, but you can see it's difficult. It's really difficult. And that leads me on, I think, quite neatly to a discussion, which we're going to have just briefly now, about services and public functions.
So where does that sit in the Equality Act?
Well, it's a different part. And that's important. It's part 3, not part 4. Different section, different scope, different rules. Mainly section 29. It's a much simpler duty. It's a much simpler scope of duty, the duty relating to services and public functions. First of all, remember we talked about who is subject to the duty as a controller of premises, landlord, manager, in relation to the letting or the choosing whether or not to let premises, all of that detail. Well, in section 29, it's much simpler than that. The person who is subject to the duty to make reasonable adjustments is simply any person who is concerned with the provision of a service to the public or a section of the public. It doesn't have to be the whole of the public. And even a section of the public that is defined by criteria. So, we only let premises, for example, to people over the age of 55, as some housing associations do. That is still a section of the public.
Yeah.
Okay, so you could make that work in terms of lettings potentially. So it's a very wide rule about who is subject to the duty. Any person concerned with the provision of a service to the public or a section of the public. And the relevant matters, remember that, what does the disadvantage relate to? It is simply the provision of the service. It's not all that stuff about enjoyment of premises, benefits and facilities relating to the use of the premises. It's just provision of the service. That's the only thing that matters. If the provision of the service is affected, if the person is disadvantaged in relation to the provision of the service, there might be a duty. And importantly, I think we touched on this at the beginning of the session, all 3 requirements, including physical features, apply to services claims.
So it seems a lot simpler. Shouldn't you bring a housing discrimination case under part 3?
Well, if it was as simple as that, we probably all would be doing it.
Never that simple.
It's never that simple. And there are some other difficulties instead. First of all, you have to find a way to argue that the letting or management of premises is a service to the public or a section of the public. I think that's potentially relatively easy to do, maybe, in relation to the letting of premises. So advertising premises to let, or having people apply to you for housing. If you're a registered provider of social housing, then deciding who to accept for housing. You can see that as being a service. But it's difficult, I think, to fit the words or the concept of a service to the public or even a section to the public into the idea of managing a particular premises, because that's much more specific between 2 entities, the tenant and the landlord, or the tenant and the manager. So I think there is a difficulty there. And there is another difficulty that should not be underestimated, which is that the rule, that little comparison test, we said it's not a particularly difficult comparison test, right? It's the disabled person themselves compared to everybody else who isn't affected by that disability. And generally the facts speak for themselves. Well, with services cases, it doesn't work like that. There is a specific carve out in paragraph 2 of Schedule 2. Schedule 2 is the schedule that deals with the details of reasonable adjustments in services cases. And there's a specific carve out in paragraph 2 of Schedule 2 that says that the requirement to show a disadvantage for services cases is not between the individual and people who are not disabled generally. It's between disabled people generally and non-disabled people generally. Why am I speaking slowly? Because that's actually quite difficult to prove.
Yeah, I'd imagine you need statistical evidence which may not be available. It's, difficult to get, costly to get, perhaps expert evidence. And I suppose if the disability was quite small amount of people suffered from
rare,
it. Rare.
Yeah,
rare in
right.
that sense, absolutely.
And almost, I mean, you could equally say that even a disability as common as depression would potentially be difficult to get statistics about, because people are affected by depression in so many different ways. It's so personal. So it's actually not to be underestimated how difficult it can be to prove that there is a disadvantage to disabled people generally, other than simply being able to say, this is how it affects me, which is something that is really not difficult to do. So that is tricky. And then there is the final difficulty with services cases. So that's as if that is not enough. Section 28 of the Equality Act actually says, deep breath, rules on services do not apply to discrimination that is prohibited by Part 4 premises, or would be so prohibited, but for an express exception. In other words, I think what Parliament's saying here is you can't get around an exception that we've created in Part 4 by just shoehorning the case into Part 3 instead. That's what this says. Now, does that mean that you can't just avoid the prohibition on the physical features duty in a premises case by calling it a services case, because the Equality Act views the exclusion of requirement 2, the physical features requirement, from premises as a express exception in Part 4? I don't know. We haven't got any cases about it, but I can logically see that you could well argue as a landlord, well, hang on a minute, if Part 4 doesn't allow you to do this because it says that there is no duty to make changes to physical features, then all you're doing by going under Part 3 is trying to get around an express exception in Part 4, and Section 28 says you can't do that.
Right.
So it is untested, it's tricky. We don't really know the answer to it. It's still the case that most of the time when we deal with reasonable adjustments, claims and defences, in housing cases, we use Part 4 and we find a way to make it work. So on that note, shall we run through these checklists?
Let's do it. I mean, someone could be making law. This is maybe where it all starts,
Absolutely.
the Section 3 exception. Okay, so I'm going to try and move this across, having obviously only doing employment law, but I'm going to try and move this across for everything we've covered to see what kind of questions you'd be asking if you're doing landlord and tenant. So first question, is the landlord or manager of the building doing things? So this is a policy, it could be an informal practice, it's that PCP. Are they doing things that causes the disabled occupier a disadvantage? That's your first question.
Okay.
Policy, disadvantage. Then you look at the disadvantage, and is it to do with the way the occupier can enjoy their home, or to do it with a benefit or facility as part of a tenancy? That's part of Part 4 rather than the employment as we discussed earlier. So that's specific to this area of law. Is the disadvantage worse for the disabled occupier than for non-disabled people?
That's the
comparative exercise.
Easy comparison exercise.
The easier one.
Yeah.
Are there things that the landlord manager could do that has a chance of reducing that disadvantage?
Yeah. So that's the steps.
They're the steps.
Potential steps.
Would it be reasonable for the landlord and manager to do one or more of those things? And that goes to the list we'll come back to that we discussed. Mm-hmm. And have they failed?
Yeah.
So I think it emphasises just how crucial it is To break this kind of case down, there's lots of case law in the employment sphere says to tribunals, you have to ask yourself these questions, look at it very, very carefully, because if you miss a step or you make assumptions about a step, get the wrong substantial disadvantage, identify the wrong PCP, the whole thing falls apart. So you've got to look at it very, very closely and ask yourself these questions and make sure, of course, you're asking your client to provide you with ammunition to answer these questions.
And if you're the landlord and you get either a defence or a claim alleging these things, work through this list. Is there a PCP that is argued at all? Have they said what the policy is?
Yeah.
What do they say the disadvantages? How do they connect it to the policy? How do they say that it's to do with their enjoyment of the premises or to do with the benefit or facility that they have as part of the premises? Sometimes that's obvious, sometimes it really isn't, and they need to explain it. Have they explained that their disadvantage is worse for them than it would be for people who are not disabled? Have they said that there are things that you, the landlord, could do that could improve the situation? Have they said why it's reasonable for you to do it? Have they said that you didn't do it? Unless they've answered each of those questions, and often they don't, you may well find that you've got a good defence by highlighting the gaps in the pleadings, let alone the gaps in the evidence. Should we go back then in our notes to that section 18B, which let's just highlight again, this is old law.
Yes.
It's not current law. It's just a useful checklist.
Yeah.
That will always be worth considering when you're thinking about whether an adjustment is reasonable or not.
It's section 18B in brackets 1, but it was of the Disability Discrimination Act 1995.
If you look that up now, you'll find that it's blank on Westlaw because it's no longer in force. But if you sort of press the back arrow on section 18 capital B, it'll take you to the last version of it that was in force back before 2010, and you'll have what Nick is about to restate.
And essentially, it's one, how effective is the step? Is the step effective? Is it practicable? What are the financial and other costs that the employer, in this context, would have to take?
So landlord,
would it disrupt any of its activities? The extent of the landlord's financial and other resources, the availability to the employer of financial or other assistance in taking the step, which really is an overlap, or and the nature of the landlord and its size.
So all of those things are going to apply, and let's just reiterate again, this is very, very fact sensitive.
Very.
It won't always be relevant to look at all of those things. Some of those things will be really obviously important in a particular case, and in another case, they won't matter at all.
Absolutely.
Okay. Let me go to the right page of my notes. I think we're going to finish up there. Before we do, if anybody does have any questions to close, please do write them into the Q&A now. In the meantime, let's just highlight as a final point while we wait to see if there are any other questions. Never assume, either in your pleadings in the court papers, or indeed in preparing witness evidence, or indeed in preparing for trial, that you can just go straight to what seems like the obvious factual dispute in a reasonable adjustments case. So never just, particularly in a pleading, go straight to, they shouldn't have applied the antisocial behaviour policy to me. You've got to start with the first bit of that test, the first question, move to the next one, move to the next one. Because if you just go straight to what's obvious, every chance you'll end up missing something important and end up with a technical defence that you could easily have avoided. And sometimes genuinely you will find that when you work through it, you actually have a serious problem with the case because of the scope of the premises provisions in the Equality Act. which are fiddly and difficult.
Yeah,
Okay.
well, you could choose the wrong PCP, which can cause all sorts of difficulties because it just doesn't logically apply in terms of the substantial disadvantage. It just, you've got to frame that PCP correctly.
Yeah, that's right. So even what seems really obvious, the very first question, what is the PCP that you are relying on that causes the disadvantage, is something that is very easy to get wrong. And it is up to you as a tenant lawyer to work out what the PCP that you want to rely on is.
Yeah.
And if you choose the wrong one, you may lose the case.
Or too vague, you know, turning around and saying, well, the policy put me at stand. Well, which part of it, is it big? Don't assume the pleadings will speak for themselves.
They definitely won't in a reasonable adjustments case. Okay, thank you, everybody. It's been lovely to have you with us this evening. To let you know, this recording is going to be both published on YouTube and also it's going to be sent to you to your email addresses by the end of this week with a feedback form. So it'd be great if you could fill that in and return it to us if you have time. That would be lovely. And most importantly, please join us at 42 BR Barristers, and particularly Neil Clark and Max Gordon, who are going to be talking in about 2 weeks' time, on the 13th of March, in a session just like this one. They're going to be talking about Section 15 claims, which is the other very common type of claim that we see in housing cases, discrimination arising from disability. So please join us for that session on the 13th of March if you can, and we look forward to seeing you then.
Yeah, I think it'll be very useful because
Yes.
in employment, the interaction between reasonable adjustments and Section 15, they can overlap, and sometimes choosing between them can be quite important. Yeah, sometimes everyone just pleads everything, and the appeal courts have said don't just plead everything. See which one fits better. So hopefully they'll be able to dovetail.
They are good companion pieces.
Indeed.
If you've stayed the course. And as 30 of you have, which is very nice, thank you very much. If you stayed the course and enjoyed this, then you will find the session on Section 15 a good companion.
You're going to love it. It's guaranteed.
Okay, thank you very much, everybody. And thank you to those of you who've said thank you on the chat.
Yes.
All right then, bye-bye.
See you. Bye.